Hi, everybody, and welcome to Chapter 5. In Chapter 5, we are going to focus on legal aspects of policing. Police, like I said in the last chapter, have an amazing amount of power and unchecked discretion. So it's really important that there's some level of oversight or that there are some limitations to make sure that there are rules for law enforcement agencies to operate within the bounds of individual rights and liberties. Because police always have to walk that fine line, and it's not an easy thing to balance, right? That balance between respecting rights and execution of their responsibilities in terms of crime control, right? So we've already discussed the rights that people have. We did that back in chapter 1. But one of the things that, or the primary thing we're going to focus on in this chapter to demonstrate the limitations on police power, police control, etc., is going to be the Fourth Amendment. And we're going to talk about Fourth Amendment protections and the exclusionary rule. So first and foremost, let's define the exclusionary rule. The exclusionary rule simply states that if officers of the law gather evidence or obtain evidence, but they do so in an illegal manner. And when I say illegal manner, I mean they violated your rights. Excuse me, they violated your rights to privacy, right? Which you have a right against illegal search and seizure, your Fourth Amendment right. If they do that, it's therefore excluded from the court. They can't use it in the court proceedings. Even if it's a dead body that they found in the closet. If they went in there and they found it illegally, well, guess what? It's going to be excluded. It can't be used. And why does this exist? To make sure that we say to police, hey, this is your bread and butter, right? Gathering that evidence for conviction, that's your bread and butter. So do it legally, because if you do it illegally, you can't use it, right? You can't use it. So I want to demonstrate this with a really famous case, which is Mapp v. Ohio, which is really central to policing in general. It's also central to keeping boundaries on how far police can go with their powers. So the case is about a woman named Dolly Mapp. It happened in 1957. She answered her door to Ohio law enforcement saying they wanted to come in, that they were looking for somebody who was hiding, somebody who was a previous boyfriend of Mapp, who at the time had been accused of sending a bomb to Don King, which was a boxing manager or something, like, in the 80s, that this person obviously had some sort of conflict with. She refused the law enforcement officer's entrance. She said, no, you can't come into my private domicile. She then called her attorney and said, hey, these officers, they want to come in. They're telling me they have to come in. They won't even tell me why, right? They just said, hey, we need to come in. We're looking for somebody that we think you know, right? And the attorney says, hey, don't let them in. If they don't have a search warrant, don't let them in. Right? Acting on that advice, Mapp tells the officers, you can't come in here. And the officers staked out her residence for a period of hours. After several hours, they went to the back door and they forcibly entered Mapp's domicile, her private domicile. They still had not obtained a warrant. They didn't have legal standing to enter her house, to search and or seize anything in her house. But that's what they did. They went in. They did not find the person that they were looking for, because he was not, in fact, at that location. But what they did find were a handwritten drawing and like a pamphlet of some kind that were pornographic in nature, meaning like, somebody drew a picture of like a naked person, right? And in 1957, in the state of Ohio at the time, that was considered pornography. It was also on the books as being illegal. She said, when the officers came in, Mapp says, I want to see a warrant. Give me your warrant. And then they just waved a piece of paper around, and she grabbed it from them. And let me see. She's like, this isn't a warrant. And they said, give it back. And she shoves it down her shirt. And she's like, I don't think it's a warrant. I don't think this is real. They end up arresting her. They take the paper out of her shirt. They take this pamphlet and this handwritten, doodle of a naked person, and they arrest her for violating Ohio state pornography laws. The most upsetting part about this is, I think, or one of the most, there's many things that are upsetting, but she was literally up for like 7 years of incarceration for this, right? So remember, the officers came, they didn't have a warrant, they enter her domicile looking for somebody who wasn't even there, and they find very weak evidence of a crime, if you can even call it that, right? Somebody doodling something. She goes to court and she gets convicted. She gets convicted of violating the Ohio state pornography laws. But she and her attorney appeal. They appeal all the way to the United States Supreme Court. At the time, the only law enforcement who needed to have a warrant to come into your domicile was federal law enforcement. Because these were Ohio State police officers, legally they didn't need a warrant to enter her premises. And her argument and her lawyer's argument was, yeah, you know what? I get that they don't, on the books at the time they didn't need to have that license or that warrant. But if we only allow this protection at the federal level against federal crimes, what's even the point of having the protection, right? If we don't make that available for state level crimes, state level offenses, then what's even the point? Ultimately, the Supreme Court agreed with them and said, you're right. This is a protection that should be at all levels, state, federal, to every individual in the United States, because your private domicile, it's your castle. It's your place where you do the most private things, the most private of behaviors, and you have a right to keep those behaviors private. People, law enforcement, can't just walk in and out willy-nilly and start looking through your drawers without some sort of legal standard. So the Supreme Court said, yeah, law enforcement officers from here on out must have a legal standing for breaching your private domicile. And that legal standing is a search warrant, right? They have to go to a judge and they have to say, here's our probable cause. And the judge has to evaluate that probable cause and say, you know what, you've got adequate probable cause. Yes, you may go in. Or you know what, no, you don't. You don't have enough here for me to say that you may breach this individual's private domicile. So this was a landmark ruling, and this was huge, right? This was huge. And Mapp went home, and she didn't have to go to prison, and all of that's good. But ultimately, what came out of this is law enforcement said, hey, Supreme Court, you guys are really tying our hands. That there are times when we literally don't have the opportunity to go get a warrant in order to do our job, right? So this is what is called, or what they call, retreat from Mapp, right? And the retreat from Mapp is often represented by an acronym called HIPCARS, HIPCARS, and each letter stands for something, okay? Each letter stands for a part of the retreat from Mapp, because the court revisited it and said, hey, you know what, you're right. There are some times you don't have time to go get a warrant. So here are the instances that you can do a search with probable cause, but you do not need to go get a search warrant. So let's go down through that list of HIPCARs. The first is hot pursuit. When someone is running away on foot, or somebody is running away, driving away, and the police are chasing them, you certainly can't expect the police to stop and say, hang on a minute, we need to go, hang out here for an hour while we go get a warrant. We'll be back, right? Obviously, the person's not going to be there when they get back. So hot pursuit, they don't need a warrant to, conduct a search. I of HIPCARs is incident to a lawful arrest. When an officer effectuates a legal arrest, he or she has the right to do a search of the individual without a warrant. Both not only looking for contraband, but also for the officer's safety, to make sure that the individual doesn't have weapons on them that can harm the officer in the pursuit of an arrest. P in HIPCARs is plain sight. If there is something illegal in plain sight of an officer, they do not have to obtain a search warrant in order to seize it and arrest you. If it's right there and they can see it with their eyes and it's illegal, that's all the probable cause they need. They don't need to go through the process and go to the court to get a search warrant. C of HIPCARs is consent. I will never cease to be amazed how many people provide consent knowing full well that there's something illegal in the near area, right? But literally, officers might approach somebody and say, hey, we would like to search your car. We would like to search your house. Can we come in and search your house? And somebody would be like, oh, sure, come on in, and the officers come in and all over the coffee table is a bunch of cocaine. Why would you give them consent? I don't know, right? I think a lot of people think it's the old reverse psychology, like, well, if I say yes, then you'll figure I'm not doing anything wrong. But no, you've just given them the freedom to come and take a look around, and whatever they find is fair game without a search warrant. They can seize it, right? Because it's in plain sight, or excuse me, because you give consent, and then it becomes in plain sight. The A of HIPCARs is automobiles. The search of an automobile does not require a warrant, because literally, if you told the motorist, like, I want you to sit tight for an hour until I get a warrant, I'm going to come back and then I'm going to search your car. Well, whatever's in the car that's illegal will be gone by then if the entire car isn't gone by then, right? So that's an incident in which officers are not tied to a search warrant. Simple probable cause allows them to do their job. The R in HIPCARs stands for regulated industry. Regulated industry is any industry that oversees legal but regulated items, does not require a search warrant. So, excuse me, this is going to be anybody who sells firearms. It's going to be anybody who sells alcohol. Your marijuana dispensaries Uh, yes, I know they're still illegal at the federal level at this point, but even if they are legal at the state level and violating federal law, um, it's still going to be a regulated industry, and an officer isn't going to need to pursue a search warrant. They can come in at any point and look around because basically, whatever it is that you're selling, whether it's legal marijuana, legal firearms, legal alcohol, it's legal, but there are limits to it. And therefore, we as law enforcement don't need, we can take a look anytime to make sure that you're following the law because this is regulated because it's got an element of danger to society. That's why it's regulated. Finally, the S in hip cars is stop and frisk, right? Officers do not need a warrant to stop and frisk somebody that they come into contact with who they suspect of being armed or involved in a crime. Um, this, once again, is ensuring immediate officer safety. We want our officers to be safe. We don't know, or they don't know when they come up on somebody who that person is, what that person's done, etc. It's literally about keeping the officers safe, allowing them to pat the person down, make sure there's no weapons that could cause officer harm so that they can have that exchange however it turns out, whether it turns out with an arrest or just saying, hey, you're free to go your own way, right? So hip cars and Mapp and the retreat from Mapp and the exclusionary rule, all of these things are super important to limiting police abuse of power and also ensuring and shoring up individual citizen rights. Now, in that same vein, I want to pivot here really briefly and talk about the Patriot Act, right? The Patriot Act. Patriot Act was very controversial when it came into existence. It literally came into existence days after the September 11th attacks. Having lived through it, I can tell you, I mean, it was super hot and cold. Like some people were like, so many people were so scared. They're like, yes, just do anything to keep us safe. And other people are like, this is going to be trouble, right? This opens a lot of loopholes for governmental abuse of power, the opportunity for the government to search and surveil you without a search warrant, right? They can surveil you electronically. They can surveil your phones. To make sure that you are not a foreign agent, to make sure that you're not working for a foreign agent, etc. And they do not have to go through the traditional channels of a search warrant if it is justified under the rubric of the Patriot Act. That is a slippery slope. That is a scary slope, but it is out there, and I want you to be aware of it, right? I want you to be aware of it. Finally, the thing that we're going to do, a couple things I want you to know before we go. Miranda warnings, which we're all familiar with because of television and movies. I want you to understand that Miranda warnings didn't always exist. I also want you to understand that there was a time where television and movies were not widespread, right? That not everybody had a TV in their home. And when they did, they only had like 4 channels in like 1952, right? So we didn't have quite the pop cultural understanding of the Miranda warnings then that we do now. So the Miranda warnings, the right to representation, the right to remain silent, etc., all of those have to be read to the individual because not everybody does know their Miranda warnings. We know it a lot more now because there's just a lot of popularity of policing shows and policing movies. But nonetheless, you would be surprised how many people have read their Miranda rights and still don't understand that they have the right to remain silent. Use your right to remain silent, right? And I also want you to know the distinction between an interview and an interrogation. So if you are in police custody, there's a really easy way to tell the difference. An interview is simply a fact-finding mission. Police are talking to you to obtain information. You are free to leave at any point, right? You are not being detained. You are not arrested. An interrogation, on the other hand, is something different. And the distinction is you are not free to leave. You are in a state of arrest. You cannot get up and go at any time. If you're ever being questioned by police and you say, I would like to go, can I go? And they say, no, you may not. Well, it's not an interview. It's an interrogation. That's how you know it's an interrogation. You are not free to leave. Interviews, by the way, can pivot into interrogations very, very quickly, depending on what kind of information is being gathered in the process. So you always want to be aware of that, right? And certainly the Miranda warnings come into play with interrogations because you are now in a state of detention. You need to know you have the right to remain silent. I'm a big fan of that right. Make sure you always use it. All right, I will see you guys in chapter 6.